the truth.
Okay. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
Y'all already know all information contained on this live is for entertainment, heavy on the mother effing entertainment, educational purposes only. All information used on this live is per the Fair Use Act, and any conclusion that you draw is on you and your mama. Not nobody on this channel, this panel, or in this chat. And another disclaimer for those who have not read the description to my channel, I am not a lawyer. Nothing I say should be used as legal advice because it's not legal advice, okay? If you do need legal advice, however, you can go talk to an actual licensed lawyer or attorney of your choosing, all right? And like the disclaimer says in the video, that you can actually see the consequences of anything that you try to run with from the channel is definitely on you, all right? So with that being said, hey, just sit back, enjoy my opinion based off my free thoughts of what I'm listening to, and y'all let me know what y'all think in the chat. Let's get started.
You can't handle the truth.
Make sure you like, comment, share, subscribe, tell a friend to pull up on your girl Mickey Truth. We is live with it. Good morning, y'all. I am late with this. This actually took place yesterday. But yeah, y'all know I was dealing with my sinuses yesterday. So we got to get into what happened at the hearing yesterday for YNW Melly. For my Melly people, y'all, I be trying, okay? Y'all don't blame me, don't hold it to my heart, okay? I be trying to keep up with all the different cases, even the ones we started with from the beginning, although I may have moved on to other things. So my Melly sector, I was coming, okay? I was coming. Good morning, Keenan. Are you going to cover the TK trial? I wasn't. I mean, he already in there for life. I wasn't. I might put a poll up on my channel to see, but not really. I wasn't. It wasn't on my list to do. But we're gonna get into it. As far as this Melly thing, like I said, I've been trying to keep up with it as much as possible, although I be all over the place. I be trying to keep up with it, okay? So I don't have long to be on live. As y'all know, I don't really do lives anymore. It's just this is an hour hearing, and I just didn't feel like pre-recording and drop it. So I'm gonna keep my lives only for like trial stuff, okay? Videos, you know, I'm a video channel, but the lives will be when we cover trials. All right. So let's get into it.
Last time we were here on March 7th, but what I have had the benefit of now is a copy and review of the orders that Judge Murphy entered on February 9th, 2024, as well as February the 16th, 2024. So I did read all the motions. I likewise read all the authority cited therein.
So Judge Wright ordered the court last hearing. There was also a C4 motion that I had filed. Mr. Evans, if you accept that, she would accept with the motion or the jurisdiction.
Well, that's the motion to dismiss the 23 case, correct?
Yes.
Yeah, I got that. So again, I won't limit any side in either way. You can present whatever evidence, witnesses, or testimony you want to save your argument to the end, I guess. So if it's just your argument, you can tell me that. The first one I want to address is the defense motion to vacate the stay issued February 16th, 2024, and or modify, allowing the defendant's motion to dismiss the charge of witness tampering to be resolved, and that would be in case number 23-10594 CF10A. So whenever you're ready, you may proceed.
So I did bring a copy of the order, but the court has the order itself. The state did file a response, and I'm actually just going to address their response. If the court had reviewed the order of Judge Murphy, although the last time I had asked for the state to be lifted, he said he wasn't going to lift it, and then he gave an analysis. He actually says in the order, even though I'm lifting it, I'm going to set down an analysis that you can follow to see how it works. Looking to the state's motion, they basically said that they disagree with the motion. They feel that, and just so the court's aware of what it is, it's not even the entire promotional video. It's a few seconds of a promotional video. It's a Gmail account to Mr. Devon's booking agent. So when you wanted to book shows for him, there was emails sent to, I believe, a Gmail account, a Facebook account, and text messages that would have predated the two alleged victims, in this case, predating their death. The state would like to argue in their motion that those few seconds of that video, those text messages somehow are materially helpful. That's the word that we need to focus on, materially helpful. And then they go on to argue that 924 says that this court is divested of all jurisdiction. They actually go on in their response and tell us, regardless, this court's without jurisdiction. They further go on and say that this court had previously ruled that there was no jurisdiction. And in actuality, that's not true. When you look at what the court had stated, it actually said, we go to page 2 of 5. The state argues that the automatic stay provision of section 924.07(1) subsection 2 divests this court of jurisdiction, and the 4th District Court of Appeal now has sole jurisdiction over this entire case. Judge Murphy said this is incorrect. For some reason, the state now wants to tell you in this motion, page 10, that Judge Murphy agreed with them and said that he didn't have jurisdiction. But in fact, what he said, I have a copy for you guys if you want me to hand you an order. Okay. In fact, what he said is that when you're dealing with collateral materials, collateral to the subject matters of an appeal, so it's important to talk about, again, what's up in appeal, text messages, emails, all predating the deaths. They want to say that somehow these emails from 2018 and text messages from 2018 somehow knew in the future that there was going to be a trial in 2023, and somehow that these two kids were going to die. There's nothing like that in that video. There's nothing like that in those text messages. It's pretty black and white. I am asking the court to relinquish jurisdiction so we can address witness tampering. Witness tampering. This court has said several times that Mariah Hamilton had no legal obligation to attend trial. That is what 941 requires the state to prove in their account for witness tampering. So to now basically mislead the court and say, hey, but these text messages and this video, they prove what?
All I keep hearing is misleading, not true. That goddamn state, what you on? Still on the same shit, obviously. Y'all make sure y'all hit the like button.
That Mariah Hamilton was supposed to come to trial? Do they prove that she was legally summoned and required to come to trial? No, they don't prove anything. They don't even prove the homicide from the case that they're up on appeal with. The state goes on to quote 924 a little bit more, so I actually took the time and read through the different cases that were previously quoted. And I would turn the court to look at Bryant versus Blunt, coming out at 261 Southern 2nd, 847. I do have a copy of the court. Again, this was quoted in Judge Murphy's case. But what they go on is they talk about this material. And it goes on to talk about what the purpose of a stay is supposed to be. And they tell us in this case that the purpose is so the state is not irreparably harmed and that they don't have to proceed to trial without the material benefit of materially helpful evidence. Every piece of evidence right now that's up before the 4th DCA does not prove witness tampering. It would not be able to come in on the witness tampering. So to say, let's hold this up. Let's keep him sitting there. Hold this case up. Let Cortland Henry sit in jail for no other reason other than what we had emails setting up a deposition. They haven't met their burden with the witness tampering, Judge. And that's what I'm asking this court to do, is to lift that stay. We don't want to lift the entire stay. Lift it as to my C4 motion. Let us proceed on the C4 motion. There are 4 counts that my client's being charged with. I'm only asking to be lifted and argue to count 1, which is witness tampering. So technically it would not even bring the case to finality for that matter. But nonetheless, it is in the court's discretion. I believe you do have a jurisdiction to make this ruling. One last thing, going to what we learned from Bryant versus Blunt, they analyzed what the stay is for. And they went a little bit further in this case to say, hey, looking at what 924 says, and it's supposed to protect, again, the state from having to proceed with evidence that's material. The evidence that's up on appeal right now would not even fall under the proscribes of 924. So there should be no stay. Nonetheless, as always, the state wants to delay this, and that would go up to why at this point we may have to entertain this bond issue. But I'll rest.
Okay. Yes, sir.
So, Judge, my recollection initially when this...
Hold on, before they start talking, I heard a end with entertain a bond situation. Hey, it already, and we ain't even halfway through the hearing, it's already like the state is still on BS. Like, it seems like all their replies to all these motions be the same shit. They either stretching the truth, not telling the truth, all that. So let's see what, if they gonna be truthful in their reply.
When we first asked for the stay with Judge Murphy, the defense agreed that these issues that were up on appeal were also material to the tampering case. But regardless of their position now, I point that out in point 9 of my response as to why these issues are material. Even though they predate the tampering, they serve as motive for why the defendant would reach out. Because, for example, in the Snapchat communications, one of the issues up on appeal is the fact that he said, I did that in response to being talked about the murder.
Judge, I'm objecting to that. That issue is not up on appeal. That Snapchat message that he is referencing is after the death of the alleged victim. So he's...
We're not part of your one at a time. I'll let you respond to anything and everything you want to. Go ahead, sir.
It also goes to his motive to engage in the behavior of tampering, which also ties into the gang allegations, because there's a lot of discussions about the gang activity in the various communications. Incentive or consciousness of guilt as to the underlying case, which would be the murder, and the materiality of the witnesses that are being involved, namely Mariah Hamilton. A lot of that stuff is discussed in those communications, in those emails, those issues that are up on appeal, which makes it relevant to the tampering charge. It's not an element, which I think is what Ms. Liberty is getting to, but in terms of evidence the state intends to introduce to support its claim as to why the defendant would tamper, it certainly has bearing there. Turning back towards the stay, I did point out in my motion that in paragraph 6, about what Judge Murphy had said could be permitted to proceed and what could not. But ultimately what governs 924.071 is whether the C4 motion would have a material effect upon the matters up on appeal, and clearly it would. So the court is governed by 924.071. The matter, this count is up on appeal, dealing with evidence relevant to it, and the C4 motion directly addresses that. So until the 4th DCA is done with their proceedings in the matter, this court is prohibited from hearing substantive matters as it relates to that.
May I respond?
Yes, ma'am.
This seems like delay tactics, Judge. You could take Mr. Demon's entire phone going back to when he was born. They're still not going to be able to prove witness tampering. 941. 4 different elements. Mr. Griffiths wants to make us believe that somehow you could look at emails from 2019 and that gives you a state of mind. Like, my client's not psychic. He didn't know this was going to happen in 2023. He didn't know his friends were going to get killed. So them saying it's material is disingenuous, Judge. So I would ask that we lift the stay. We proceed on the C4 motion, which is only to 1 count. There are still 3 other counts. We're not bringing this case to finality. I am just addressing the tampering, because on its face, they have not met their burden with the tampering, and they'll never meet their burden with the
right, so, so I'm looking at, standard jury instruction 21.10, tampering with a witness, which is 914.22, subsection 1. That's what you charged Mr. Dennis with in count 1. So what you're telling me is the state's position is that some of the evidence that is subject to the appeal that's currently in front of the 4th DCA is evidence that you would use not only in litigating the pending motion to dismiss, but you'd use it in the trial as well.
Correct.
Is it me or is it? Hold on, let me make sure my volume up. Because is it me? It's all the way up. Maybe that's just the audio. All right, y'all. Y'all just joining me. Like I said, we are watching the motion hearing from yesterday in the YNW Melly trial or case. The Melly sector of the truth team has been on me saying I haven't been keeping up with the Melly thing, and I'll be trying to keep up with everything that we've covered, all the cases, even though my content kind of hadn't switched up eventually. I'm still trying to make sure I keep up with them. So y'all know I don't go live anymore. I'm not a live channel, I'm a video channel. But when we do the trials and hearings, I'll go live. Okay, so that's what we're doing today. Y'all make sure y'all like the live, share. Get in the comments, let me know what's going on. Y'all know motion hearings are so boring, but it's part of the process. I'm doing homework, okay? But I am listening and I'll chime in and I'm checking the comments, okay? So let's get back to it.
Okay. All right, so listen, I certainly understand the defense position, and I certainly would like to bring all these matters to fruition as quickly as we can. However, that being the case, I'm nevertheless constrained to follow the law. The plain text of 924.071 subsection 2 says, appeal by the state from a true pretrial order shall stay the case against each defendant upon whose application the order was made until the appeal is determined. If the trial court determines that the evidence, confession, or admission that is the subject of the order would materially assist the state in proving its case against another defendant, and the prosecuting attorney intends to use it for that purpose, the court shall stay the case of that defendant until the appeal is determined. So I don't think I have any choice here but to rule in the state's favor on this. I don't have any jurisdiction. You all disagree about what the evidence does or doesn't show. I'm certainly not in any position, nor is this an evidentiary hearing where I'm going to decide who's right or who's wrong about that. But I'm looking at count 1. The state has to prove that this alleged tampering was with the intent to withhold testimony or withhold something.
Morning, Justin.
Effective testimony or truthful testimony. And then element number 3 says that the official proceeding involved in the investigation of one of the choices is capital offense.
So, Judge, what they have to prove with 941, which is the most important element, is that Mariah Hamilton was served with legal summons to attend an official proceeding. In this case, under that statute, 941, it defines what official proceedings are. The only applicable one would be the trial that occurred in May of 2022. So with that in mind, that they must prove that there was...
You're making a jury argument. We're not at the motion to dismiss. The only way that I can grant your motion is if I decide under 924.071 subsection 2 that this evidence can be related at all. And the state's telling me that it is related. I understand your position is that it's not related, but
I'm in the position that 924 does not apply because it is not materially related. And I will also I know you're ruling, but with that said, if that was so much the case, then why haven't they stayed Cortland Henry's case or Terrence Mathis's case? Because this evidence still can't come in their case. Cortland Henry's attorney could come and adopt my C4 motion and argue it himself. At this point, they have not moved to state.
Did y'all see? Isn't that the actual DA that just turned around? Like, You can't make this shit up for real.
that case and say that evidence so
My bad, y'all say I'm doing too much.
important. So why could that work with the co-defendant, but not with Mr. Demons? Because there's no logic to it, Judge.
I have no idea, nor do I have to decide which side's behaving logical or not, in my opinion. Lucky for me. So, on this one, again, pursuant to
Good morning, Nene.
071 subsection 2, the defense motion to vacate the stay issued on February 16th, 2024, and or modify, allowing the defense motion to dismiss the charge of witness can be resolved. Respectfully, this may be denied for the reasons I just stated on the record. I will issue the appropriate written order.
So although you have a role that would just leave this impression with the court, we did have this hearing, we did discuss the state. The state had representatives that had no issue with this proceeding forward, and here we are back as state while he waits. Thank
Okay.
you.
Okay, the next one is defendant's motion to compel discovery or an alternative to reveal the extent of the state's intrusion on the defendant's right to due process, client confidentiality, attorney-client relationship. So, Mr. Anderson, I think you filed that whenever you're ready.
He did, Judge, and I talked to Mr. Aronson before the court took the bench today. When that motion originally came in, I emailed your judicial assistant and listed out some reasons why the state would not be ready to argue that today. I'm still in the process of creating a response as well as investigating some of the issues that were raised. I'm not prepared to argue that today. This
Is he saying he ain't ready? Come on, man. You done had 5 years at this point. And that's one thing that's kind of irritating, just, with the judicial system altogether. When now with the defense attorneys, they expect, like, even if the defense attorney can't be there, like another one should be able to fill in just like that. But these prosecutors, they just be like, oh, somebody else was over this. I haven't had time. Like, man, fuck all that shit. Do your job. Y'all supposed to be with that. Yeah, like y'all supposed to have that together. 5 years is crazy. And you still talking about you ain't got something completed. Come on now.
when the bond hearing is set.
Okay, that request is denied. Go ahead, sir.
Erna, here is case law. You said you read it already,
I
but
did.
I'll give you a whole packet because my secretary would be very upset if I make her make these copies and I don't give them to anybody.
Understood.
Your Honor, since you've read the motion and you've read the case law, it appears to me, appears to us, that there is, you previously did not believe that you had the authority to conduct a hearing based upon whether there is a conflict between Ms. Liberty and Mr. Demons as far as her still representing him. I believe one of the cases that I submitted says that in fact the court can hold that type of hearing. But that's not the gravamen of this motion. The motion is really focused on the other Sixth Amendment rights: attorney-client privilege and effective assistance of counsel and due process under the Fifth Amendment. Now, all the cases I gave to the court, there's not one on point, because this area of the law seems to be incredibly fact-specific. But the one thing that we know from all these cases is, A, the state should have revealed a year ago, a year and some odd months ago, that in fact Ms. Liberty's Apple accounts had been searched. They did not do that. The case law seems to be very clear also, Your Honor, that because they have this material, and I jump ahead and I'll jump back, we don't know what they have. What we know is that they've seized Ms. Liberty's Apple accounts through a search warrant. But when asked whether there were other search warrants or whatnot, the state still has not revealed whether anything else of Ms. Liberty's accounts have been searched. They did tell us that in fact that no other attorneys' accounts were searched, but during a federal hearing as to Mr. Demons being released, it was the interpretation of the attorneys there that the sheriff's office was saying there may have been other investigations of other people. We interpreted that to mean our investigator. We are not positive. It was muddled as far as what was being said. So there may be other investigations going on that we don't know of. But as to this, We know at least Miss Liberty's Apple account was searched and seized, and everything in it was seized from the inception of the account on, prior to her knowing Mr. Demons, prior to the murders, or prior to anything. They go back, I believe, to 2019.
Hold on, prior to her even knowing Mr. Demons is crazy.
In January is when they're seeking, the information went back as far as that, but it also goes back into the historical stuff of the accounts, when it was set up, things like that. So even though it's maybe delineated for 2019, you get information that is part of the entire account. So they have all these records. We don't know what they are, but we have a problem because they have all these records. The case law, if you've read it, says under the Sixth Amendment, if client confidentiality has been breached, we have to specifically file a motion delineating what we believe is client confidential.
They definitely are, Judge.
We cannot do that if we don't know what they have. We have the right to go into whether or not the prosecutors on this case have been tainted by the material that they received in the investigation of Miss Liberty. Remember, I only represent Mr. Demons. I don't represent Miss Liberty. So how this affects Miss Liberty is irrelevant to me. But they have seized all of her accounts. In that, are there comments made about our trial strategy? Are there emails? Are there communications, text messages about our trial strategy? How about whether or not she just met with Mr. Demons and Mr. Demons says this, and this? The bottom line of all of this is they did a mass seizure of everything in Miss Liberty's Apple accounts. And in order to be able to defend him properly, we need to know what they have. We need to know whether it was received properly, whether it was reviewed properly by a taint team, whether they went beyond the taint team and things were discussed with the prosecutors. Now, if you went through all these cases, you notice that during these hearings, prosecutors are called to testify, agents are called to testify. We don't know which prosecutors to call. We don't know which agents to call. We know nothing. We are totally in the dark. Again, if you've read all this case law that I provided for you, there's case law that says we have to demand all the material be returned and that they have a duty to return that case law. They have a duty to return everything to us without them having copies. As I said, each case is a little different from the next. I'm not here asking the court to dismiss the case. I'm not here asking the court to sanction the state. What I'm asking the court is to make the state reveal to us all that they have so we can determine whether there is a conflict, and as I said, that's not the gravamen of this motion, but whether there's a client attorney privileged material that they have in their possession, whether they have an effective assistance, whether they've destroyed our effective assistance of counsel because they now know our trial strategy or what we're going to do, what we're planning. And as the case law shows you there, that takes away the effective assistance of counsel. And then overall, we need to know all that's going on because there's the Fifth Amendment due process rights that you have. And even if everything they did up until this point allows them to get this material, you have to still eventually look at the totality of the circumstances and has my client's due process rights been violated? And that's going to be a bigger picture starting from the time that they withheld Brady material and things of that nature. Well, we're entitled to know everything they have. We're entitled to see everything they have. We're entitled to know what witnesses have seen everything, who took part in this, what information was shared or not shared with this trial team. We're entitled to all those things because without it, we cannot effectively represent our client.
So before I ask the state to respond, I see the 6 bullet points specifically that you requested. Return seized property that belongs to Mr. Denham. We'll skip number 2 for a moment. provide notices of defense to all the documents that have a bearing on attorney-client privilege, provide the protocol that was used to segregate the information, provide a list of witnesses who were involved in obtaining the search warrant, and any and all documents related to Ms. Oakley's account. I don't know if the cases that I read support all those specific requests, but my question is this: as to number 2, provide copies of all materials in the state's possession obtained from the accounts. Doesn't that solve your whole problem, at least for now, if I just order them to turn over everything they got?
It's a start, but it's not a finish. And the reason why it's not the finish, we still need to know whether this material was passed on to the trial team, whether they had a taint team. Those are things that we still need to know. So although, as I said, that's a start to order this all to be returned to us, or copies of all of this, it doesn't get us to every place we need to go. How, by just them turning it over to me, how do I know that this incredibly confidential piece of information wasn't seen by the taint team, called up Mr. Griffiths and said, God, you can't believe what we just discovered here. This will help you in the murder case. Here it is. We don't know that. I'm not accusing anybody, but the case law is pretty clear. We're entitled to find out if it was shared with these prosecutors.
If there is such material. And again, I'll repeat what I talked to you about before, but Ms. Liberty's sitting right over there. You can have a discussion with her anytime you want. So I suspect you probably know what's included in her.
Your Honor,
she knows what's included in her.
No, Your Honor, you're wrong, and I don't mean that nasty to the court. Will you please tell me the communication that you sent to so-and-so on January 23rd, 2022? You don't know.
Listen, quit while you're ahead. I think you're probably entitled to all this stuff.
Excuse me?
I said quit while you're ahead, because I think you're probably entitled to all this stuff. But Mr. Griffiths, over your objection, I know you said you wanted to prepare some response, but, and I might be skipping ahead to Mr. Edelstein's motion next, but I entered an order February 18th, 2025, at least in part granting the request for discovery that you all were to comply with 3.220. So you got these materials in December of 23. I don't see any discovery submission on the docket. So
Correct.
am I correct? The state has not made any supplemental discovery disclosure regarding any of these materials?
Correct.
Okay. So I presume that means you're not going to use any of this at the trial because
Correct.
you have an obligation to do so and you
Yes.
haven't done it.
And that was my comment to the court.
If you're not going to use any of it at the trial, and again, to repeat myself, as I seem to do every time we all get together, since Mr. Demons is entitled to heightened due process because of the penalty that's involved here, you haven't charged Ms. Liberty with anything. You've had over 17 months to do, 15, 16 months to do so. Despite your all's position, I've previously found that it's not an ongoing investigation because you haven't done anything. Now you're telling me there was no materials involved that were turned over to the state that even warrant you supplementing discovery. So if that's the case, what is the harm with me granting the number 2 request that you all just copy everything that was given to you and give it to the defense so they can see what it is? Because I can't find any harm at this point. So what's the harm?
So let me back up a little bit. So despite what the court feels is no longer an open investigation, it does remain an open investigation. I have met with the detective. The investigation is still open.
Oh, well, but that could be forever. I
Additionally,
hate to interrupt lawyers, but that could go on forever.
I can tell the court the case is actively being worked.
Well,
And
that
on,
doesn't mean.
and on top of that, well, because obviously I can't disclose to the court exactly what's going on.
So what's the plan, sir, if you don't mind letting me in on this? Now that I've special ordered 750 jurors in September, are you all planning on arresting Ms. Liberty 10 days before the trial
Judge,
starts?
I can't disclose that at this point.
Well, okay, so my finding over your objection and the way I'm going to proceed forward is that there is no ongoing investigation. So that's the way I see it. Go ahead to your next point.
All right, Judge. Well, following up with that, let me find because I was working on a response. Criminal investigation is considered active as long as it's related to an ongoing investigation with a reasonable good faith anticipation of securing an arrest or prosecution in the foreseeable future. There is no statute or regulation on how long a investigation remains open. That's Florida Statute 119.011. Florida Freedom Newspapers versus Dipsey at 478 Southern 2nd, 1128. Avila versus Miami-Dade County at 29 Southern 3rd, 401. There's other citations, but that's the first two. There's no time limit. And this, as an officer of the court, I'm telling this court this remains an open investigation. It is currently and still being worked. The materials that they seek, first of all, there's been no seizure. The case law actually talks about this. Copies of her Apple records were provided to BSO, which were then subject to the filter team, but she was never deprived of those records. She still has access to them. The lack of seizure, so there's been no seizure. The lack of seizure is echoed in Ray's search warrant to Google, which is at 232 Federal Supplement 708. And Ray's search warrant issued to Google at 264 Federal Supplement 3rd 1268. U.S. versus Lorna, 333 Federal Supplement 3rd 172. Matter of search info associated with a redacted Gmail account at 2017 Westlaw 2480752, which all cite to U.S. v. Jacobson at 446 U.S. 109. A seizure of property occurs when there is some meaningful interference with the individual's possessory interest in that property. There's been no seizure. We have copies, yes, but there's been no seizure. As the court has pointed out, she has copies, she has access. So she has what the state, she probably has more, honestly, but she has what the state has. So she has access to whatever it is that we've reviewed.
And so then, if that's true, the harm in me ordering you to turn it all over, so then she'll have 2 copies of what she already has, is what?
I'm telling the court there's been no seizure and it remains an open investigation.
Let's say you're right, which you're clearly not, but let's say you are. He has to decide who he wants his lawyers to be. We keep having the same discussion.
And
how many trials do you want to do?
And I'm protecting my open investigation, Your Honor.
No. You all decided to do what you decided to do. Anything else you want to tell me about this?
Yes.
All right, go ahead.
So turning towards the points that were raised in M. Neal, which was in the defendant's motion, was evidence or is evidence going to be used at the trial directly or indirectly produced from the intrusion? No, we're not using anything. That's the subject of Mr. Adelstein's motion. We're not using anything. Was the intrusion by the government intentional? Yes, that's why we obtained a search warrant. Did the prosecution receive otherwise confidential information about the trial preparations or defense strategy as a result of the intrusion? No, we have not received anything. The trial team handling this case has received no confidential communications. And were overheard or any conversations or other information used in any way to substantial detriment to the defendant? No, because we're not using anything. We don't know anything about their strategy from anything that's been recovered. So they can't even establish the prongs that would require the court to compel us to turn over these materials.
He's right about that. We're not, this isn't an evidentiary, and you all aren't making an evidentiary hearing because you call whatever witnesses you want, but no one's calling any witnesses. You guys are the lawyers. You're not witnesses. So I understand what you just said, but there's no record evidence of that.
I know.
You want to call some
I'm proffering to the court.
Proffer's not going to do it, sir. Today's April 1st. His trial's September the 10th. That's why you might have noticed, although I don't prejudge anything, every time someone asks me to slow down on something, I deny it because it's time to do this work and get done with it. So I haven't heard anything yet that says don't turn it all over. So anything else?
And again, Judge, that is why I asked for additional time, because 4 days prior to this hearing, with the issues that I raised in my email to your judicial assistant, I still have not completed all my work in terms of
You're telling me
responding to
if
this.
I order you all to turn it all over to me.
That's exactly what we're hearing. They still not together.
I'm going to determine that nothing qualifies under 3.220, nothing they're entitled to prepare for trial.
Judge, we're not using anything.
That wasn't the question.
I understand the court's question. I'm telling the court, I don't have access to everything because obviously there's a filter team in place.
You don't know.
Right, but I don't know because I'm not entitled to know, nor will I know.
But the state hasn't turned anything over.
Because we're not intending to use it. It's not going
That's
to
not
affect
what
Mr. Demons'
3.220
case.
says. It's not what you intend to use. That's their standard.
But that's what
They have to turn over
the
what they
case
intend
law
to
and the
use.
statutes
You have
talk
to
about.
turn over everything that you know about.
If it intends to be used at trial or it has any material bearing. And based upon what we are aware of and what has been turned over, it is not.
Anything else on that issue?
One moment.
And lying. It's catching up with
Sorry,
him.
Judge. I'm sorry. The one other issue, which is the other reason we asked for it, is BSO was not noticed of this hearing. They are the investigators in this case. They are the ones in material possession of these documents. They're the ones that actually know more about the investigation than we do. And I feel they have a right to be heard as well, because in some of my initial research, when I was looking at things like public records requests, the lawsuits always involve the sheriff's office
This isn't
versus
a public records
I
request.
understand, but I believe that our sheriff's office also has standing.
You're 3 for 3. I don't agree with anything you said. Anything else?
Judge, again, I still haven't had an opportunity to fully address the motion, which is why I was asking for additional time.
Okay, over your objection. So, the defendant's motion to compel discovery or an alternative motion to reveal the extent of the state's intrusion on the defendant's right to due process, client confidentiality, attorney-client relationship is going to be granted in part and denied in part as follows. It's granted as to paragraph 2. Giving the state 20 days to provide the defense copies of all materials in the state's possession obtained from Attorney Raven Liberty's appellate counsel. The other 5 requests are denied without prejudice, depending on the outcome.
Thank you, Your
I
Honor.
will give you a written order on that. Next. The defense motion to exclude.
That was a win for the
impose
defense.
sanctions. Ms. Davidson,
That's the
that's
second
your-
one so far.
that's your motion, sir. Go ahead.
Based upon your Honor's ruling just now, and the state's representation, this is as far as excluding evidence. However, I do ask the court to understand that the state ignored your order.
They're telling me that they have nothing to compel under this. I get,
You know,
I mean, if I got a lawyer sitting in front of me in a death penalty case that tells me something and it turns out to be completely wrong, that lawyer's gonna have a large problem.
fair enough,
They're gonna have a large.
fair enough. Based upon that,
What do you want to do with this motion, sir?
we will withdraw at this time
Okay,
without prejudice.
so the defense motion to exclude and impose sanctions that was filed March 25th, 2025 is going to be withdrawn in open court. I'll make no ruling on it.
Fair enough.
Next. This is the second motion for pretrial release, so that requires an Arthur hearing, so I have to give you a date for an Arthur hearing. So did Mr. Demons ever have an Arthur hearing?
He did,
And which judge was that in?
Judge Murphy, and there is an order dated, I have an order for Judge Murphy as well, September 23rd, 2023, and I'm being told Judge Siegel did one as well.
He's had 2 Arthur hearings.
I can't say for Siegel, I have the order from Judge Murphy.
Regarding COVID, so Brad Cohen had filed a motion.
I saw that for medical reasons, but that probably wasn't really an Arthur hearing.
Yeah, there was not one.
So who did the actual Arthur hearing?
Judge Murphy, after the mistrial, there was one argued, I believe, by Mr. And we didn't present evidence, we basically relied upon the mistrial.
Well, the trial transcript would be the.
That would be the evidence.
Right. Well, I'd let each side present whatever additional evidence they want, but if someone wants to get me the trial transcript, I'll read it before we do it, and then I'll let each side present whatever additional evidence, witnesses, or testimony they want. Or certainly, Mr. Jones would be entitled to do that. I think at this point, he has to prove a change in circumstances, does he not?
So, Judge, when I put it to a note, there's the 2 prongs that's kind of rely on it. There is the proof evident of guilt, but that's not where the inquiry stops. It says, yes, if the state can go ahead and prove that, that's fine. But there's a second step to that, and that's appropriateness. And that was the.
Yeah, then I can exercise my discretion. So are you stipulating that the proof of guilt is evident and the presumption is great? And you just want me to have a hearing on part 2? Or do you want me to have a hearing on the whole thing? I'll give you as much time as you need.
Alright, so we'll proceed by our way.
Okay. So let me handle the other matter. Just pause on that, and I'm gonna give you a date. I'll check with everyone's schedule. And I'll give you a date. You tell me how much time you need, and we'll do that. So,
Just can I inquire one thing, so the entire trial transcript you want?
Hold on. I think they're going to schedule another bond hearing. If that's what I got from that, it was a lot of back and forth. I think that's what they're going at. There's going to be another bond hearing.
So I can get it printed and deliver them.
that would be great. If someone just wants to put it on a thumb drive.
I think we have an electronic copy that we can supply to the court.
Thank you, Mr.
I think
President.
they-
What's up, Christian?
Obviously, voluminous, broken up into days and witnesses and all that.
That's fine.
It's
Just make sure whatever, I will read before the hearing, whatever either side wants me to see ahead of time, just make sure the other side has a copy of whatever it is that you send me, and then I'll let you introduce whatever additional evidence, witnesses, or testimony you want, and then, as Ms. Liberty correctly points out, I have to make a determination as to proof, evidence, presumption, grade, and then number two, even if I were to do so, I have to make a determination as to whether it's an appropriate exercise of my discretion to grant a bond in the case. So I'll be happy to read whatever you need me to read ahead of time. So just pause on that for a second for the date. Let me go back to the one matter that was left over from the last time, the defendant's motion for order to show cause. The state should not be found in contempt for the ongoing willful flagrant violation of the court orders. I read that. I likewise read the state's response. I likewise, what I didn't have the benefit of last time was read the two orders that were previously.
Good morning, Deshaun.
February 9th, 2024, February 16th, 2024.
I'm sorry, I'm just trying to figure out which motion you're referring
It
to.
was the first one listed on the previous notice of hearing the last time we were here. Number one, defendant's motion for order to show cause for the state of Florida's ongoing willful and flagrant violation of a court order dated February the 9th. I didn't have the benefit of the state's written response. I didn't have the benefit of the orders, so I told you all that I would hear that today, which is April the 1st. So
I think we kind of worked most of this out. We did, I think the crux of my complaint with that motion that day was setting depositions, and Mr. Griffiths gave me a whole plethora of depositions. Somebody is in my office today actually setting up notice of depots. So my issue, we resolved, Judge.
okay, so this is this
I
going
don't
to
know.
be withdrawn and open
It's not
court?
real at this point.
Ms. Liberty, you're on file.
Yes, Judge.
Okay.
Yes.
So Ms. Wilcox, defendant's motion for order to show cause by the state of Florida should not be found in contempt for ongoing willful flagrant violations of the court order dated February 9th, 2024. This motion was filed February 8th, 2025. That one's going to be withdrawn in open court. So that's all that I have today. I'm going to give you a hearing date for the renewed Arthur hearing. Ms. Liberty, how much time might you need for that hearing?
How long will you take to get him the transcripts?
We're gonna go back and email the transcripts this afternoon. I think Taylor's a bit. Oh, they're huge. We'll be delivering them on a thumb drive either this afternoon or tomorrow.
Here, here's a drive I brought for something else that I can give.
Oh, no, don't fit on a USB. We can get the judge just kind of. We have, right, make sure you guys have a copy, make sure we're all.
I think the issue is that we have the transcript divided by witness and topic, so it's not in any kind of.
Whatever I'm saying is.
So you know that Travis, the last clerk, actually had filed in the docket a day-by-day synopsis of what happened in trial. So
But that's always been, we just try to put that together, and I want to know that we still have it.
No, I just printed it, Travis did it.
Oh, that, but I don't know that we have all the transcripts. We know what happened each day, but we don't have.
If you
We're
give
missing
me the
transcripts.
USC this week, like by the end of the week, I will take on that
Oh,
task.
no, if you want it that, I may not have it, what we have, and you can tell me if there's anything. We can all confer, judge between each other and see if they have things we don't, if they have things they don't, and figure out what
Yeah,
transcripts
listen,
are
I'll
missing.
set this as soon or as far away as you need, but when we do have the hearing, how much time do you need? I can give you as much time as you need. You want a whole day?
Give me a whole
2
day.
days? Tell me what you want.
A whole day? Just a whole day, yeah, if you read the transcript, I think like you can do that in a whole day. How long do you need to say?
We're gonna rely on the transcript, so.
Yeah.
We're just gonna go to argument.
You want to do it on Monday, April 21st?
I am.
That's
We're both Miss
Easter
Collins and
Sunday.
I are out that day. Or you're out the whole week.
It's Easter Sunday, is what I'm saying.
That's the 20th, I think.
We're all the Monday.
You want to do it on? Monday, May the 5th?
I could start at like 10:30 that day, just because I have a lengthy change of plea that morning with multiple.
Is Tuesday, May 6th better?
It is for me. I don't know about Ms. Collins.
It might still be in trial since we performed for a judge of the day, but if not.
Can we do it the week after? I'm in state on a case I'm trying to finish up in California that week.
I'm open that
Yeah,
week.
that week after, I should be.
I'm in a 4 co-defendant murder trial, starting on Wednesday, May 7th. I can do any day, basically between now and then. I have one other trial, but once May 7th comes, I'm in trial.
No, he's starting trial May 7th.
So May 6th.
May 6th.
Again, this is just for the Arthur,
Mhm.
nothing
Yeah.
else. State, does May 6th work for you?
It works for me, Ms. Collins. Hopefully we'll be done with trial. If not, I'll be doing some heavy lifting.
Okay. Defense, does May 6th work for you?
Yes, other than I have a calendar.
What's up, Ted? Coco for sure. They is tap dancing, square dancing right now.
I'll give you the
My
whole
calendar call is at 1:30, so I may have to just.
In this building?
Yeah.
I can handle that for you. At the time, just remind me. Okay, so, Ms. Wilcox, put down, Mr. Simmons, put both case numbers down, please, for, defense, motion to set bond, Arthur hearing, Tuesday, May 6th, at 9:30 a.m. This case remains set for trial, both cases, September 10th, at 9 o'clock. State, is there anything else that you need me to do regarding Mr. Bevins today?
One moment, Your Honor. No, nothing wrong.
Defense, anything else you need me to do regarding Mr. Bevins today?
Your Honor, thank you very much.
Ms. Wilcox, is that otherwise conclude FT this afternoon? So then the reason FT is otherwise going to be in recess until tomorrow, which is Wednesday, April the 2nd, at 8:45. Have a good rest of your afternoon.
All right, y'all. That's pretty much that. Shoot, y'all. I'm sorry. I be having to wake up too early, go to bed too late. Next, bond hearing is, I want to say May 6th. Is that what they said? Or did they agree on April 21st? I think it was May 6th. It's bond hearing. I'm gonna try my best to be on time and do the stream in real time. However, don't hold me to it. We're gonna get to it, okay? Like I said, I just want to catch up so we are up to date. As y'all notice, we have been covering this case for years at this point. One thing we can count on is the state, no matter who the prosecutor is, the state is going to be all over the place. And I could have sworn the dude that's on there now is the actual DA, but I could be wrong. I kind of feel like that's the DA, but I could be wrong. Hey, I be trying to cover everything, Christian. It be hard, but the Melly sector, I'm going to tell y'all, the Melly sector of the Truth Team and the Chicago sector of the Truth Team be up on me like, yo, you don't forgot about us. I be trying to keep up. It's like, boy, I've been stuck in the Atlanta sector for a minute. Now Texas got a grip on me, but I'm making my way around. Like I told y'all, I don't do lives anymore. Because this channel is just not a live channel. I got my regular people that tune in, but for the most part, I just do videos. However, when it comes to hearings and trials, I'm gonna have to be on live. So you can definitely count on me to go live with that so we can interact during this. But for the most part, it's really, I'm not gonna drop a video on this because it's really nothing more. It's really nothing other than a bond. But I'll wait. Cause I'm gonna tell y'all the truth. I done got like 3 videos about Melly getting out on bond and ain't happy yet. So I'm gonna wait until the bond hearing and see what happens before I make a video about it. Okay. But yeah, y'all, I got to get ready for work now. Had to get social media out the way. Definitely appreciate everybody for pulling up, especially you just say, hey, he's a prick. I ain't gonna lie. He worse than the last one. Okay. The last one wasn't that bad, but this one, you can tell he just be talking out the side of his ass. In my opinion, of course, okay? But yeah, so that's what we got going on. Y'all make sure y'all follow up on the videos. Y'all know last month I dropped 115 videos. 115 videos is a lot. I didn't even realize it. So I'll be hard at work, okay? So y'all make sure y'all go and interact with it. I need all my mods to be under the videos. It shouldn't be a video where I don't have no comments. I need the mods to be commenting. I need my subscribers to be commenting. I need the friends of my subscribers who probably ain't subscribed yet. I need y'all to be up under that comment and subscribing. Interaction is key, okay? Yeah, you hear my throat is hurting, okay? It's hurting right now. I think I'm getting sick. I'm about to nip that in the bud, okay? But now I do a lot of talking, so that could be it too. Yeah, they have been getting strict for sure, okay? So yeah, y'all make sure y'all run up the engagement. Y'all know views, I get views, but I don't get views, if that makes sense. I'm not a big view channel, so what helps me grow is my engagement. And we've been doing a good job. Now, don't get it twisted now, because we've been doing a good job, but we need to do a little bit better, more consistent, okay? I'm going to do my part by dropping the content. I just need y'all to get in the comments or whatever. Even if you're dropping an emoji, just get down there, run it up, help me out, okay? Y'all know I'm a struggling YouTuber, okay? Help me out. With that being said, I'm going to close out because I do got to get up and get dressed. But I appreciate y'all for waking up, tuning in with me early this morning. Some of y'all are already at work. I'll be on my way there in a few minutes. With that being said, y'all already know everything I said on here is definitely my opinion. Y'all know how I feel about my opinion. And like I said throughout the video, that's my opinion. And if you don't like it, guess what?
I'm like, fuck, yeah.
Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast. Mickey talks the truth.
I got truth on my mind. I got truth on my mind.